Shannon Stillwell was officially a free man after accepting a plea deal for his remaining charges. Gotti suddenly had a warrant that stopped him from going home. And then Miles Farley is taking an Alford plea. 3 different courtrooms and 3 different hearings all in the same morning. Apparently Gotti was the aggressor in his stabbing. Like he went up to someone for some reason and tried to fight them and then they stabbed him in self-defense. So that's an interesting detail. But yeah, hit subscribe, here we go. Alright, first off we got the remaining co-defendants. Looks like Miles Farley is taking a plea here, boys. This one is in Judge Whitaker's courtroom. Oh look, that's Demikian Garlington. He hasn't taken a plea yet.
Guilty pleas that are going to be tendered today by any of the defendants.
Yes, Your Honor.
There's Miles and his lawyer who got arrested, remember? For the bullshit medicine debacle.
Mr. Farley, could you state your true, correct, and legal name for the record?
Remember, he's charged with murder for walking into a gas station. That's all they have on him.
Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? How far have you gone to school?
26 and got a bachelor's degree.
26 and has a bachelor's degree.
And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing? And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that is in your best interest to do so?
Yes.
And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts that this plea of guilty places you in the same position as if you were convicted after a jury trial?
Yes.
Okay. And how do you plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC 183572?
Guilty on the Alford.
And Mr. Farley, is this Alford?
Oh, Alford plea. Oh, shit.
Guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to?
Yes.
And you understand that you may have a limited right to appeal this guilty plea conviction?
Yes.
Your Honor, had the case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th of 2013 and May 8th of 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise that YSL. In doing so, they did
Paige looks so over this shit. Look at her face.
through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting...
Bro, she's so over it. She wants a body to shut the fuck up.
Protect and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor. It's also my understanding he qualifies for the first offender treatment, and the recommendation would be 5 years to be served on probation.
5 years probation. So this is an L for the state, bro. They had this guy charged with murder, and they wanted him to go to trial with everyone else, and now they're letting him out on 5 years probation. They kept him in jail for years for this.
Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
Upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon, understand?
Yes, ma'am.
All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Yes, ma'am.
All right.
He's taking a guilty plea for RICO, an Alford guilty plea for making a clothing brand, not even trolling. That's all he did. 60% of you aren't subscribed. Come on, hit the subscribe bell.
Yes, Judge, I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alford. In 2019, him and a friend created a clothing item, a hat, that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using this youth term slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area: his creativity, intelligence, tenacity, his bravery in taking things as far, Your Honor, putting his foot down when he was faced with this government abuse.
I love his lawyer. Faced with this government abuse.
Is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he's a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home.
How embarrassing for the state. They got to drop a murder charge for this guy to take Alford plea. What an L.
And that's why I think Alford is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. While you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right, I find there to be a factual basis for this plea. I will accept it under Alford, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you.
All right, there we go. Judge Whitaker looks over the shit. 4 more people left in the YSL RICO trial. Demikan Garlington, Demise McMullen, Christian Eppinger, and Tinquarius Mender. Now in a different courtroom, Yak Gotti is present, trying to get out on bond for his jail charges. And here comes Kayla Bumpus.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. Well, as the honorable court, I'm pretty sure knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to get in the bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're going to get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened.
She ain't wrong. Rice Street is almost like a trap. Because if you don't defend yourself in there, if you get in a fight, you're going to get a charge for something.
He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to give him a bond. My client knows this all too well because he was actually a victim of a stabbing on December 1st. You are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are going to work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, what kind of work he would be able to do. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, and I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society.
Notice how the days are shorter, but your to-do lists aren't? Power through your busy days with Factor's no prep and no mess meals. Factor has you covered with over 35 different meals every single week. They also have over 60 different convenience options like keto cookies, pressed juices, and smoothies. You can choose between 6 menu preferences that help you manage calories, maximize protein intake, avoid meat, or simply eat well balanced. Because Factor's meals are chef prepared and dietitian approved, you're going to love how it tastes, but also how it helps you reach your goals. And of course, Factor is cheaper than takeout and dine out. You could put the money you're saving towards holiday shopping or your financial goals in the future. My personal choice would be the grilled steakhouse filet mignon. Let me tell you, boys, what an absolute banger of a meal, boys. Trust me on that one. Using your time more efficiently during these dark months is so important. Let Factor take the shopping, cooking, prepping, and cleaning away from you. Head to factormeals.com/50cuff and use code 50cuff to get 50% off your first box plus free shipping. That's code 50cuff at factormeals.com/50cuff to get 50% off your first box plus free shipping. Absolutely amazing deal. Go copy some meals, boys. Back to the video.
Until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail.
I like Kayla's attitude.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record, just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these two cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot, it's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and I'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around, and something as simple as you can't go to those studios, because those studios are ones where we read about, and it's a great music making place, and the next day there's a dead guy in the parking lot, and it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're going to be working on getting a studio in wherever he resides, so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay.
All right, I think Kayla did a pretty good job. Now the state is up trying to keep him locked up for whatever reason.
Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll...
Warrant for what? Oh, he's not going home, dude.
On 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, my understanding, just from hearing a little bit from Mr. Thomas's, co-defendant Thomas's lawyers, is that not all, they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim.
So they're saying Gotti was the guy attacking someone, pretty much.
Your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm gonna call it the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick And essentially, there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
from Mr. Kendrick or from Mr. Wimberly?
Both. But
Okay.
with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions. One out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case. We believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022, and this day, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 allegations of violence and 3 are allegations of possession of contraband, or were the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth.
So they're saying Gotti was stabbed in the head because he was the attacker.
Violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assault. And so, while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge.
Exhibit A, pointing right at Gotti. He's the reason why it's unsafe.
We're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Ms. Bumpus, I want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Well, Judge just said he has to look into the warrant before he does anything on this. So, Gotti's staying in jail, boys. That's unfortunate. All right, now we got Shannon's hearing. Apparently, there's a plea deal that has been reached in Shannon's case. So, here we go. All right, there's Shannon. Let's see if he's going home, boys.
Good morning, Mr. Jackson. Good morning. As you stand before me today, you are here on 3 indictments. Is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will, we raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And spell it, please.
Shannon Jackson, SHANNON, JACKSON.
All right, so we're going to begin with case number 23 SC 188183. You understand you'd be entering a plea of no contest as to the participation in criminal street gang acts, which is 1 and 2.
Yes, sir.
You understand you'd also be entering a plea of Alpha B, North Carolina, in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items by.
Yes, sir.
So no contest in Alfred, I think?
Count 2, possession of a firearm by commission of a felony, and count 3, possession of a firearm by a convicted felon.
Yes, sir.
And then the counts 4 through 8, the possession of prohibited items by inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call habeas corpus, and that's if you want to challenge the constitutionality of this plea.
Yes, sir.
The evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value.
This motherfucker crashed into someone and then stole a bystander's car.
But did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. While the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. A judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street.
Depending on what day it is at Rice Street, even the prosecutors in this shit know it's a hellhole.
Judge, I'll begin with what the negotiated recommendation is on that's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Possession of a controlled substance, that judge recommendation is 3 years commuted to time served. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10. The count 2 was going to be 10 to serve 3 commuted to time served, balance on probation, as opposed to 10 years probation.
I'll refer to you as you were the one actively involved in negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for count, for 22 SC 181814. Count 1.
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time. It's a statute minimum of 1.
Okay.
So
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
Okay. Thanks, Max, for clearing it out there. 12 years probation. So he's going home, it seems like.
Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There would be no contact or communication, either directly or indirectly, with any named co-defendant, and there is to be no possession of a firearm on his person.
This nerd is yapping, dude. He's absolutely yapping. I don't even know what he just said, dude.
Be able to distinguish Mr. Jackson from other defendants that may be argued were similarly situated.
All right, thank you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the Metro Atlanta area, with exceptions for the Atlanta airport. Judge, that would also...
How long, though? That's crazy. Oh, so it looks like it's 5 years banishment from Atlanta.
Include that he has to maintain gainful employment while on probation. There is to be no contact or communication, directly or indirectly, with any named co-defendant.
A lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is. Yeah.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he will be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
The court is going to find that the defendant has entered pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alford plea or just a regular guilty plea. The defendant is to be sentenced to 10 years to serve 3, commuted to time served. Count 2, 5 years, probated to serve consecutive to count 1. Count 3, 5 years, probation to run concurrent to count 1. 12 months on count 4, commuted to time served. 10 to serve 3, commuted to time served. Count 2, 5 years probation, concurrent to count 3. Count 1, 3 years to serve, commuted to time served. So the people who used to be your friends or the ones that say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with. Because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. From my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail, and unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out in 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem and they don't have to worry about you. And more importantly, the court doesn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years. And nobody's going to say yes to probation under any circumstances.
No more chances for Shannon here.
Will be for 5 years because they didn't negotiate a term. So that's for 5 years. And you can come back for special occasions and the state and your attorney can work out with those occasions.
5 years isn't too bad, like realistically. Like think about how long ago 2019 was for us. Like it's not the end of the world. And it's for his own safety, to be honest. See, 10 years is pushing it. Like Thug getting 10 years out of Atlanta, that's pushing it. But 5 years, I'd be like, all right, I'll take that. Shannon going home, baby. That's crazy. Hey, Shannon, if you're watching this, brother, take advantage of this, man. Go get a real job or start rapping. Stay out of the streets. Because if you fuck up, you're going to prison for years. You gotta take this serious, brother.
That concludes the business after probation is done for the United States.
Yes.
See you tomorrow.
All right.
Position 7 on the final plea calendar.
Hold on.
Excuse me, position 1 on the final plea calendar.
All right. Position number 1, indictment 23 SC 186907. Marquisha Knox.
Look at the smiles. And there we go. 4 more people left in the YSL RICO trial. Apparently that starts in February. If there's no more, please comment down below what you guys think. Hit subscribe. Love you guys. Peace out.